All rise. The Court of Appeals Division 1 is now in session.
Thank you. Please be seated. Good morning. This is the time set for oral argument in our cause number CV130484, Medrano versus Phoenix Police Department et al. Counsel, we are recording today's proceedings, both audio and video recording. So when you step to the podium, if you would, please identify yourself and the parties that you represent. Each side will have 20 minutes for argument, and appellant's counsel is responsible for watching the clock and reserving any time for rebuttal that you might desire. We've read the briefs, we've conferenced the case prior to argument, and with those preliminaries, counsel for appellant, you may proceed.
Good morning. My name's Stephanie McCoy-Locum. I'm at Aiken, Shank, Hawkins, and Riccardi on behalf of appellants Estella Medrano and Liliana Valencia. With me at counsel table is James Kuhl, also from Aiken, Shank. This case, as with all cases, involves a story about a woman who was arrested for a crime she didn't commit, a woman who was separated from her newborn daughter for more than 80 days and then placed on house arrest for a crime she didn't commit. But the issue before this court is about legal process and whether Estella Medrano was subject to a valid legal process. Because this is a case, an appeal from a motion to dismiss, we can look no further than the facts pled in the complaint to answer the question. And I'll represent to you. If we look at the facts in the complaint, the answer is no. There was no probable cause to arrest Estella Medrano. She was not subject to a valid legal process. But this court doesn't have to reach those ultimate answers. What we're asking you to do today is to give us the chance to flesh out our theories and discovery, to proceed to a jury, and to hold the city defendants accountable. As a threshold matter, I'll note that the trial court dismissed these claims based upon a date of accrual. And Dube v. Likens and Gus Rosenfeld v. Prudential Insurance both hold that accrual is actually a question of fact for the jury.
Let me ask you, is under that authority, is accrual a question of fact for the jury in all cases for all claims?
Under Dube v. Likens and Gus Rosenfeld, we need to look at the claims at issue. And here, the primary claim is the false arrest and imprisonment claim. So we need to look at when the accrual of the false arrest and imprisonment claim arises. And if I may, I'll turn to that issue next. Despite the factual allegations in the complaint, the trial court found that Ms. Medrano's claim for false arrest and imprisonment accrued on May 21st, 2011. That's the date that she was arrested. The trial court presumed that because Ms. Medrano knew that she was innocent on the date that she was arrested, her claim accrued. But this proposition misstates the law and takes a short view of what a claim for false arrest and imprisonment is. A claim for false arrest and imprisonment under Slade v. the City of Phoenix holds that it occurs when a person is detained without consent and without lawful authority. There's no dispute that Ms. Medrano was held without consent, so the question becomes if she was held without lawful authority. And Wallace v. Cato, a case that's cited extensively by both sides in this appeal, tells us that the statute of limitations on a claim for false arrest and imprisonment accrues when the false imprisonment ends. So we have to look at, when does Ms. Medrano's false imprisonment end? Well, the answer, based on the facts of the complaint, are either when she's arrested, when she's released, or when she's held pursuant to a valid legal process. Here, because the probable cause statement includes material omissions and misstatements, because the grand jury process included material omissions and misstatements, she was not held pursuant to a valid legal process.
But let me ask you this. Wallace talks about the false imprisonment ends once the victim becomes held pursuant to such process. It seems to me that a collateral attack on the process isn't contemplated by Wallace or Rondelli or Hansen, which are the Arizona cases. What authority is there for you to collaterally attack the process in this context?
Your Honor, that's one of the questions and one of the issues with Judge Anderson's ruling. If the claim accrues on the date that she was arrested, it's inviting a collateral attack on the process.
Well, but we're moving beyond the arrest to the initial appearance where the commissioner finds probable cause. So what authority is there for you collaterally attacking the elements of the initial appearance?
As set forth in our papers, we discussed the elements of the statements that were made during the initial appearance and to the grand jury, and the fact that there were material misrepresentations and omissions in those statements. Our position is, due to that judicial deception, there is no valid legal process at issue here.
So the argument is the initial appearance meant nothing.
Correct. For the purposes of establishing the accrual of the claim.
And I understand, and when we're in the context of count 3, but what authority do you have to support that proposition, legal authority?
We cite the judicial deception cases in the SIR reply brief. That would be the primary authority that provides that those misrepresentations undermine the validity of the process.
Counsel, a question for you. If as in Wallace, it says that the false arrest ends at the time of the arraignment, at the process, and the nature of a false arrest claim, false imprisonment claim, is that there's a lack of due process, then when would the false arrest or imprisonment ever end in an arraignment? Wouldn't every single false arrest claim survive an arraignment because there's a lack of probable cause? Therefore, the arraignment doesn't mean anything because it's an arraignment held with a lack of probable cause.
Well, Your Honor, our position is that the purpose of the arraignment, the purpose of the initial appearance, is to satisfy the probable cause requirement, and that by allowing a magistrate judge to make a determination of probable cause, we're instituting a valid legal process. As you know, an initial appearance doesn't require proof that the defendant committed the crime, only that there's probable cause to hold her.
A lot of these initial appearances are probably less than 30 seconds. But what I'm getting at is, if you're going to attack the probable cause that is presented to the magistrate at the initial appearance, all of these claims assert there's a lack of probable cause. So when would an arraignment ever constitute legal process? What would be the meaning of these cases then? It's sort of embedded in the claim itself that there's no probable cause, so the arraignment doesn't really mean anything. So if you can collaterally attack the arraignment every time just by alleging it, then there would be no end to legal, or there'd be no legal process that would ever commence.
Well, Your Honor,
unless you allege the due process claim, like under the Fourth Amendment, or your civil rights claim, where you're saying this was a violation of the 14th Amendment or something, Fourth and 14th Amendment, that's a different issue. That's not the claim you've made here.
Your Honor, we have filed a 1983 claim in district court, but the issue before us, I believe, is when the claim accrues, and we have to look at the allegations of the complaint in order to make that determination, to allow us to proceed to discovery to determine if that probable cause actually existed. If I may turn to the next, I guess, group of claims that...
Counsel, before you go just there, and let me interrupt you with one housekeeping matter. In addressing the motion to dismiss, there were some documents provided to the Superior Court with respect to the initial appearance, correct?
Yes, Your Honor.
That did not appear in the pleadings. There is no objection the Court's considering those documents. Is that fair?
Correct, Your Honor.
Thank you. I appreciate it, and sorry to interrupt.
Turning to the next kind of group of claims that Judge Anderson disposed of, those are the negligence and emotional distress claims. The trial court held that those claims accrued before August 10th, 2011. We presume that the court chose that date because it is the date on which Estela Medrano was released from jail and was then subject to house arrest.
Although isn't it also 180 days before the notice of claim was filed? I mean, doesn't it happen to be both those?
Your Honor, yes, but the dismissal of those claims also requires us to conclude that nothing in the complaint alleges actions that give rise to Ms. Medrano's negligence and emotional distress claims after her release from jail. And simply, that's not the case on the face of the complaint itself. And with respect to the malicious prosecution claim, just so we can make sure that I can make sure that all of my bases are covered. The malicious prosecution claim, Judge Anderson dismissed with the explanation that the plaintiff failed to allege that the city maintained control over the investigation sufficient to sustain the claim. Again, looking at the well-pled facts in the complaint, our position is that the city defendants initiated the prosecution, they continued the investigation, they maintained control over that investigation through the course of the prosecution, and thus were active in the process sufficient to sustain the claim. I'll represent that we attempted to do some pre-suit discovery, we attempted to do some pre-motion practice discovery in this case to learn about the PPD officer's involvement in the process. Our request was denied, and so we're stuck again with the facts of the complaint. And we believe that on the facts of the complaint, we have pled sufficient to sustain.
You allege anywhere that the officers withheld information from the prosecutors or gave false information to the prosecutors?
Your Honor, I believe it's paragraph 86 of the complaint, we make factual allegations with respect to the malicious prosecution claim and the control that they maintained. It was difficult for us to, at the notice of claim stage and the complaint stage, to know what the police told the prosecutors when. We do know that the probable cause statement that was issued by the PPD officers or was submitted by the PPD officers did include misstatements and errors.
Yeah, but there wouldn't have been a prosecutor present at that stage of the proceedings. Do you have any information that any police reports were withheld from the prosecutors, or that certain facts were misrepresented to the prosecutors at any point?
Your Honor, I'm on a slippery slope. I know that the trial court was looking only at the complaint in this matter. We've conducted discovery subsequently in the district court matter, and so I don't want to cover the factual development.
Let me address it in this fashion. I don't see anything in your complaint that alleges that. Can you point me to an allegation in your complaint?
Like I said, I think that the paragraph 86 is the paragraph in which we address. It's not an overt statement that they withheld a police report or they withheld information from the prosecutor. It is an allegation that the information that was presented to the prosecutor and was used by the prosecutor in making the presentment at the grand jury in the initial appearance was erroneous. And finally, with respect to being sensitive to the time, the loss of consortium claim, the last claim that I would like to address with you, belongs to Liliana Valencia. And Judge Anderson dismissed the loss of consortium claim, stating that, well, it's a derivative claim, so you have to have a primary tort in order to sustain this derivative tort of loss of consortium. And under 12502, the minor child's derivative claim for loss of consortium is told until the 18th birthday. While we would agree if the trial court made a determination on the merits of the underlying torts, that Ms. Valencia's claim would be barred, here the judge disposed of the primary tort claims on procedural and jurisdictional basis. So Liliana Valencia should be allowed to present her case about the primary torts in order to reach her loss of consortium claim. With that, if you don't have any further questions, I'll reserve the remainder of my time for rebuttal.
Thank you.
Thank you.
Ms. Burke.
Thank you, and good morning, Your Honors. Lori Burke, and I am here on behalf of the appellees. Let me address the issue that was just being discussed about malicious prosecution. Counsel for Ms. Medrano referred the court to paragraph 86, suggesting that that contains an allegation that the police withheld information from the prosecution, and there's no such allegation there. It states, quote, by arresting Estella Medrano for armed robbery, placing her in jail, and referring the matter for criminal prosecution, defendants instituted legal proceedings against Ms. Medrano, end quote. That's the entire paragraph. There is no allegation that the defendant officers failed to provide any information to the prosecutor. And the factual allegations in the complaint make it clear that the county attorney initiated and continued with the prosecution. None of the grand jury transcript is attached as an appendix item to our SIR reply, and if you look at the officer who testified before the grand jury and was called by the prosecutor to testify, it's not one of the police officer defendants who was involved in the investigation. So they had no involvement from the time of the arrest no involvement since the time of the arrest.
Can I interrupt you?
Sure.
All of those points seem to me very valid in the context of a motion for summary judgment, but I'm wondering whether, looking strictly at the 12b6 dismissal of the malicious prosecution claim, the complaint is minimally adequate to survive dismissal. And I guess I'm looking at different paragraphs from the ones that appellant's counsel referred us to, paragraphs 94, 96, 75 through 77.
Right.
And I understand her argument that without discovery it was difficult and consistent with Rule 11 to be much more specific. So given the liberal construction under Rule 12b of the complaints allegations, is there enough to survive here?
I don't think so, Your Honor. Paragraph 94 that you referenced states that the county attorney's office relied in whole or in part on the faulty investigation conducted by the Phoenix Police Department. And the facts that support their claim that it was a faulty investigation are set forth in the preceding paragraphs of the complaint. And so there is no allegation that those facts or how the investigation was done, what was learned during the investigation was withheld from the prosecutor. They're critical of the prosecutor in the complaint for relying on that improper or deficient investigation and going forward with the prosecution. Paragraph 95, they say that the prosecutors should have known that the arrest and prosecution lacked probable cause based on how the police department conducted the investigation, which they had information about.
What about paragraph 96? The police were motivated by malice or acted with reckless indifference.
I think that's 97. Is that what?
96, is that 97?
96, I'm interested in as well, because it says defendants instituted and or continued the criminal prosecution of Medrano without probable cause.
Right,
and then 97 as well, if you could address both.
Sure. Reciting simple legal conclusions are insufficient under the Culling v. Auto Owners case.
And I understand that, but that assumes these are legal conclusions as opposed to factual allegations.
Well, but the specific factual allegations that are contained in the complaint as to what transpired with respect to the prosecution are that the prosecutor made that decision, the prosecutor initiated charges going back to 94. The county attorney's office relied on the faulty investigation conducted by PPD and made the decision, decided to initiate and continue its prosecution of Medrano. So their factual allegation on who initiated and continued the prosecution was the prosecutor. And in paragraph 75.
Before you go to 75, and I want to hear about 75 as well, but doesn't that require us to say effectively the complainant could only properly allege that, and I'll use the county defendants as a generic term,
Sure.
Either the county defendants who are not part of this appeal or the city defendants, but not both, continued the prosecution? I mean, it doesn't seem to me it's necessarily an either or as a pleading matter.
Right.
Not as a factual matter, but as a pleading matter.
Well, I think to meet their their pleading requirements for pleading a viable claim against the city defendants, they do need to state that factual allegation. They only state it against the county.
And I heard you say that, but that paragraph 96 still causes me to struggle with that as a pleading matter.
But their allegations are very specific as to what each of the city defendants did. And the city defendants aren't factually alleged to have done anything following the arrest. The only allegation that relates to anything after the arrest is in paragraph 75, where they allege that the case agent, who's not one of the individual defendants in this case, who was continuing to investigate, told Ms. Medrano's attorney that the police department was now 70% sure that she wasn't involved in the armed robbery. But continuing to be involved in an investigation doesn't mean you're exerting control such that that would give rise to a malicious prosecution claim. And then if you read that together with paragraphs 76 and paragraph 77, in 76 she alleges that yet the defendants continued to hold Medrano in custody and the county attorney's agents objected to her release from jail and continued their prosecution of Ms. Medrano. So it's the county attorney who's making the calls here that's continuing the prosecution. And then in 77, she alleges that over the objections of the county attorney's agents, Medrano was released from jail. So she's not alleging anything to suggest that the police department defendants or anybody from the police department was exerting any control over the prosecution.
Is county attorney's agents a defined term? I see exactly the language you're talking about. And what I'm trying to figure out is if it's because I didn't remember it being expressly defined earlier in the complaint.
No, but she doesn't allege in the complaint that any of the City of Phoenix police officer defendants are agents of the county attorney. On the issue of false arrest, do you have any more questions about malicious prosecution? On false arrest and false imprisonment, plaintiffs' counsel are confusing the issue of accrual with the substantive elements of the claim for false arrest and false imprisonment. The doctrine of judicial deception is something you would assert in bringing and maintaining a claim of false arrest or false imprisonment. That doesn't go to the issue of accrual. A valid legal process occurred when she was held over after the initial appearance. But even if somehow the court agreed that there wasn't a valid legal process, subsequently on May 31st, a grand jury indicted her. So a second valid legal process took place under which she was held over for trial.
And is that part of the complaint?
That is something that the court can take judicial notice of. It was discussed in the briefing by the parties.
And is that, just so I'm clear, is that something that was presented to the Superior Court?
The transcript itself was not, but the grand jury proceedings was discussed at the oral argument. Judge Anderson asked plaintiff's counsel if Ms. Medrano was represented throughout the criminal case. She responded that she was represented throughout the criminal matter. And then he asked if she ever challenged the grand jury proceedings. And she responded, no, she did not. So she had that opportunity if she believed that probable cause didn't exist. There are procedures under the rules, as your honors know, for overcoming a finding of probable cause by the grand jury.
And I appreciate that. What I am, recognizing we're here in 12B6 land, I get really kind of obsessive on knowing what's properly in the record and what's properly
Sure.
not. And I appreciate that.
Okay. And so the issue of accrual involves simply when was she held over pursuant to legal process. and that was on May 21st, the date of her arrest. Plaintiffs didn't cite to any cases that would suggest that a claim for false arrest accrues sometime after the date of the arrest, and plaintiffs' counsel hasn't directed the court to any authority that would suggest that a claim for false imprisonment would accrue any time after the false imprisonment ends. If they attack the determination that there was probable cause or that there was misconduct that led a judge to determine that there was probable cause, that goes to the substantive claim that needed to be filed in a timely manner, and here it was not. On the issue of the negligence and emotional distress claims, Your Honor was correct that I believe Judge Anderson, and we argued that the August 10th date, or the determination that all of the claims accrued before August 10th was because then her notice of claim would have been untimely.
But would it be timely as to events occurring after August 10th?
If there,
I recognize she was released home detention, and so if you threw out anything preceding August 10th, why would it not be a viable claim from August 10th on?
well, Wallace v. Cato makes clear that just because the extent of your damages aren't known at a particular time, your cause of action still accrues.
As to false imprisonment and false arrest, let's throw those out for a minute, but focusing on the set of claims that you were just addressing.
Well, she hasn't alleged that the City of Phoenix defendants did anything after that point in time. So there's no basis in the complaint even alleged for a negligence or an emotional distress claim.
Let me ask you about that. Aren't there allegations in, and I'm looking at paragraph 77 through 80 with respect to sort of post August 10, 2011 and forward allegations? I understand that the complaint largely builds on what happened prior to that time. There's no question, but I struggled with those specific paragraphs with respect to whether for those four claims, the negligence and the emotional distress claims, that to the extent they relied on those actions occurring on or after the 10th of August 2011, that there might remain for that portion viability in a 12b6 sort of motion. So it's a long-winded question, but if you could address those.
In those paragraphs, she is not alleging any conduct on the part of the City of Phoenix defendants. In 77, again, she's alleging that over the objections of the county attorney's agents, Ms. Medrano was released from jail and placed on home arrest. And then 78 is that while she was on pretrial service release, her counsel contacted Christina Ruelas' father. Christina Ruelas, as you know, is the person she's alleging actually was the female involved in the armed robbery. 79, the father identified her, and then 80, after Ms. Medrano's counsel tells prosecutors about this information, she's then released. So there are no allegations concerning the City of Phoenix defendants in those paragraphs. And any damages continuing, even by virtue of being on home release, really relate back to the alleged arrest without probable cause and false imprisonment.
Well, couldn't you envision a world in 12b6 land where, if you have a false arrest, say on January 1, and someone's detained for 6 months, and then they see a judicial officer and they're released on home arrest, which is not simply being released. There are significant restrictions on a person's life and liberty interests for the next 6 months. and that all that is factually actionable. Let's assume that, okay? Because I don't hear you conceding that, particularly at this stage. Couldn't you see a world where even if the 6 months where the person was incarcerated was time barred, that the 6 months where they were on home arrest would not be?
No, because another act on the part of the defendants isn't what caused her to be on house release. It's her being on home release after being released from jail is just a continuing damage from the negligent act, or from the act that caused the extreme or outrageous conduct that led to her being incarcerated in the first place. There's not alleged a new act. It's just it's a growing damage.
What if at the hearing on, we'll call it July 1, where the home arrest starts, and again, this is a hypothetical, but that the charging officer knows there is no probable cause to do anything other than dismiss with prejudice, I suppose, but still objects to any release. Could that be an actionable tort that doesn't trail back to January 1, 2000, or January 1, beginning of year?
You mean if the allegation in the complaint was that both the prosecutor and the City of Phoenix defendants opposed her release to home release?
I'm in a hypothetical world, so let's set aside, let's just say
Okay.
there's one set of defendants in that hypothetical world, and I'm asking about accrual, not, I understand the control issue is here, but couldn't that fairly read in 12b-6 say, look, that's a new actionable?
I don't
Or
think.
does it all trail back to the improper
I think it
arrest?
all trails back because it all relates to the original arrest by the Phoenix police officers. That is, I don't think their objecting to the release would create a new cause of action.
Well, my hypo is that the prosecutor, with absolutely no basis at all, not this case, knowing that there's no probable cause, objects to release.
Oh, and so would there be a new cause of action?
Would that cause a new accrual date? And that's not what the complaint alleges here.
Right.
But
I'd probably have to research that a little bit.
Well, and to further complicate the hypothetical, wouldn't it depend on whether that objection was successful or not? I mean, if it's an objection that is of no moment because the court releases the person, then I think that might alter the accrual analysis.
Right, I think that's a good point.
What she said.
Right, because that is a good point, because if the officer or the prosecutor objected to the release and she's released anyway, then there's no damage as a result of the new act.
what if the objection, what if in fact the defendant wanted to be released without being on home arrest? The prosecutor objected at all, and as a result of the objection, they're placed on house arrest, which is far more restrictive than release on terms.
Well,
For accrual purposes only.
so you're saying released on their own recognizance, not charged
That's what
as
they wanted, but
dismissed.
in fact they're released on home arrest, given the objection of the prosecutor.
Well, then, again, I'd have to go back and research
Fair
that
enough.
issue.
Fair
that
enough.
one.
Fair enough.
Yeah, so I guess there would be a damage in that case. So I guess arguably you'd have a new cause of action, but again, that's not what's alleged here in the
Understand.
complaint.
I have one quick question for you.
Sure.
Sometimes the conditions of release hearings, the case agent testifies. In this instance, was there any testimony taken from the officer, or was it just the prosecutor arguing against release?
I don't know the answer to that. I don't know if it was even argued. The motion. Your question was, were
These officers that wrote these reports, were they ever called into court
No.
to testify on a release issue?
no, they were not. And I have 20 seconds left, so unless the court has any further questions for me, I'll conclude. Thank you.
Thank you. Rebuttal.
Thank you, Your Honors. I will be cognizant of the record that was before the trial court, but I'll be honest, it's a little bit difficult for me to sit in this chair knowing what the district court case has revealed in light of what Ms. Burke is saying. And let's turn to the information that was in the trial court record. The Form 4 included no information about the store clerk identification, included no information about the store clerk's statement to officers that the female in the store says no, no, don't. The Form 4 included a false statement. It said that Ms. Medrano was arrested with incident. In fact, she was arrested without incident. And the Form 4 included no mention that the ID was of a 3-year-old MVD photo in which Estella Medrano was 3 years older, or 3 years younger, pardon me, and approximately 40 pounds lighter because she was 5 weeks postpartum.
What about Ms. Burke's argument, though, that this doctrine of judicial deception, which is what I understand you're arguing, doesn't have anything to do with the accrual issue, that it would relate to your substantive claims if they were to go forward?
Respectfully, Your Honor, none of the cases that the trial court relied on in reaching this decision involved a process in which there was an attack on the process by which probable cause was held or probable cause was found. By precluding an attack on the process, we are essentially allowing city defendants, police officers, or other agents to shield themselves from liability by making misstatements that the criminal defendant may or may not be aware of.
Can I ask, though, on that point, and I appreciate what you're saying, but we're not here, I don't think, to decide how the substantive law of the types of claims that your client is making should be construed. We're here to see whether your client has done what she needed to timely be able to air those in court. So I think those are somewhat different.
Your Honor, there's one other argument that we make in the papers that we haven't discussed yet, and that's the Garrity argument. The argument that forcing Ms. Medrano to file a notice of claim.
I would object that this goes beyond the scope of my argument. It's not proper rebuttal.
Well, if you can tie it to the question that we're looking at, I mean, I agree the constitutional issue wasn't discussed earlier. So what's your basis for going there now?
The Garrity argument, I think, goes to why accrual in the face of the challenge to the probable cause should be delayed until she's held pursuant to valid legal process or until she's released from custody.
Okay, I think we probably need to leave it there on the constitutional issue. It's been briefed, but it wasn't argued, so it's a bit unfair to the appellees to now go into that in any depth.
And Your Honor, I would like to rebut two additional things that Ms. Burke said. One is that Judge Anderson did raise the issue of the collateral attack on the probable cause finding during the criminal case. And this court can take judicial notice of the docket in the criminal case. And you'll note that Ms. Medrano on July 7th of 2011 requested an extension to time to challenge the grand jury proceedings. And in fact, Ms. Medrano was challenging the grand jury proceedings, but that matter never proceeded to a hearing or a determination by the criminal court because the charges against her were dropped. So the fact that there was a collateral attack on the probable cause supports the position that she should be permitted to collaterally attack the probable cause determination on the facts based alleged in the complaint. And one other thing, Judge Thama, you were asking significant questions and considerable questions about the activities of the city defendants after August 10th, 2011. I'll point you to paragraph 129E of the complaint, which states that the defendants did not investigate Cristina Ruelas. It's not just affirmative actions that caused Ms. Medrano to continue to be held without probable cause, but it's the inactions as well. The city defendants did not investigate Cristina Ruelas, and that contributed to her being held and continuing to be held on house arrest.
How does that fit in, though, in the prima facie elements of those four torts, the emotional distress and negligence, which typically, not always, but typically require affirmative action to be actionable as opposed to inaction.
Your Honor, Ms. Medrano, when on the date that she was arrested, she offered DNA evidence, she offered fingerprint evidence.
And I understand if we're talking about what happened prior to August 10, 2011, I understand that. But, you know, the question is, if we find that that's a tipping point in terms of what's timely and what's not, actions that occurred on or after that date, if the allegation is that defendants did not investigate her Rios as a possible suspect, that's inaction. In other words, if it was to stand alone, you'd be alleging or purporting to allege these four prima facie torts based on what someone didn't do.
Your Honor, if you look at the factual allegations as a total picture, we allege that the
And I'm with you there, but my question is, what if we can't? What if we can't look at anything before August 10, 2011? What if that's the way we think the law is?
But even if we look at the acts post August 10, 2011, and we look at the allegations in the complaint, Ms. Burke says there are no allegations that the city defendants did anything after a certain date. Well, the city defendants are included in all of the references in the claims portion of the complaint that say defendants. And there are numerous allegations that say defendants acted to maintain the prosecution, defendants acted to continue the prosecution, and those are affirmative actions. The failure to investigate is simply an additional portion of that picture. And I see that my time is up, so I appreciate your time. Thank you so much.
Thank you. Thank you both for your arguments. They were very helpful. We will take this matter under advisement and issue a ruling in due course. And at this time, we will stand in recess to prepare for our next argument. Thank you.